Good evening and welcome to NAMI New Jersey's webinar series. My name is Jennifer Hughes and I am the Associate Director of Program Quality Assurance at NAMI New Jersey. Today's topic is estate planning and administration. We are honored to have our distinguished speaker, Jared Aberweiss from Hinkle, Pryor and Fisher joining us today. Attorneys at Hinkle, Pryor and Fisher PC have over 70 years of combined experience providing specialized legal services to families of children and adults with a wide range of disabilities and seniors. They have argued many of the precedent-setting cases affecting individuals with disabilities in New Jersey and Pennsylvania. Jared Aberweiss concentrates his practice in estate and trust matters, guardianships, and adult services. Jared enjoys ensuring the rights of individuals with disabilities are protected. He writes and speaks on topics concerning the rights of individuals with disabilities and their families. Jared was admitted to the New Jersey Bar and Pennsylvania Bar in 2014 after receiving a Juris Doctorate from DeQuincy University School of Law. At DeQuincy University School of Law, Jared served on the DeQuincy Law Review as a senior graduating cum laude. Jared is currently a member of the Mercer County Bar Association and volunteers to provide pro bono services to the local community. Jared and his family actively support Special Olympics of New Jersey. Outside of work, Jared enjoys golfing, cooking, and traveling. He currently lives in Yardville, New Jersey with his fiancee, Lissa, and their dog, Jax. Jared, we are grateful that you are here and we look forward to your presentation. I will now pass it on to you.
Thank all of NAMI New Jersey for allowing me to present to you guys tonight. As Jennifer had mentioned, my name is Jared Aberweiss and I am an attorney with Hinkle, Pryor and Fisher. Okay. Hopefully everyone can hear me. So again, thank you NAMI New Jersey for having me. Really at Hinkle, Pryor and Fisher, we focus on four main areas, which is estate planning, guardianship, special education, and adult services. So tonight's presentation is on estate planning and estate administration. So as Jennifer had just mentioned, just a couple of things before I get started. There will be some time at the end of tonight's presentation to ask questions, but please understand that, a Q&A session is not really a substitute for seeking independent legal advice from an attorney. Everyone has a different situation. Many situations are fact sensitive. So if you really have an issue or if you think you may have an issue, you really need to contact an attorney to discuss that matter further. Also, I believe, as Jennifer mentioned, everyone's microphones are currently on mute. Just helps to keep down some of the background noise. So let's start. Why is estate planning important? It's a very common question that I'm asked. And really, it gives you peace of mind knowing that if something were to happen to you, your affairs will be handled in the manner in which you choose. Putting together an estate plan, helps guide the other people who are left behind, as far as, or through your powers of attorney, which we'll get into, how to handle your affairs. All right. But more importantly, when your loved one has special needs, there's a strong possibility that he or she is receiving some sort of governmental assistance. Oftentimes that governmental assistance, has income and resource limits, which can affect eligibility, for those specific programs. So when we're talking about governmental assistance, generally we're talking about Medicaid and SSI, or perhaps services from DDD, being the Division of Developmental Disabilities, certain forms of housing assistance, and so on. All right, there are some others. So, generally speaking, when a person is receiving governmental assistance benefits, they're required to maintain resources less than $2,000. Now, there are exceptions to the $2,000 resource limit, but for tonight, we're going to focus on this figure. All right, so if an individual has resources which exceed $2,000, then he or she may not be eligible for that governmental assistance. Now, specifically, let's say SSI, right? So SSI has a $2,000 asset limit or resource limit. So you've got to be careful, to make sure you stay underneath the resource limit and make sure that your income isn't too high. Now, one way to avoid having assets counting as a resource against an individual is to create a special needs trust. And we're going to get much more into that in a little bit, but just wanted to give you guys an idea. So what happens if you do nothing and you don't create an estate plan? So that's another common question that's asked. So really, in every state, they have these, what they call as default laws, as far as what's going to happen to someone's assets, if someone were to pass away without a will. And what this law is called is, or statute, is an intestacy statute. All right. Now, again, generally speaking, for tonight's general overview, when one spouse passes away, everything that they own, all of their assets, are going to pass to their surviving spouse. But when the second spouse passes, or in a worst case scenario, where let's say both spouses, God forbid, were to pass away together, then everything is going to be passed equally to your surviving children. That includes, perhaps a child or a young adult child, that has disabilities and is receiving this governmental assistance, which we had just talked about. Again, I want you just to keep in mind, assets may and they will pass differently. If you or your spouse, let's say, have been married in the past, or if there's children from a prior marriage, certain circumstances, will certainly alter, everything passing to your children. But generally speaking, once you and your spouse or sole parent were to pass away, if you pass away without an estate plan, there is a good chance that more than $2,000 will be distributed to, a child of yours who has a disability, and that may jeopardize and will jeopardize any benefits that he or she's currently receiving. So it's very important to be mindful of the asset and income limits. So when we talk about an estate plan, generally there are 4 documents that we're talking about, and we're going to address those in order tonight, just to make it easy. All right, and that is first being a last will and testament. The second is a financial power of attorney or durable financial power of attorney. The third is an advanced healthcare directive or living will or healthcare power of attorney. And lastly is that special needs trust that we had talked about before. Not really part of the estate plan, but also part of the estate plan, which I'll dive more into later, is we're just going to briefly talk about ABLE accounts, ABLE, which stands for Achieving a Better Life Experience. It's not really part of the estate plan we create as an attorney, at least not at Hinkle, Pryor & Fisher, but it's certainly part of the overall package that I want you to be mindful of. All right, so let's start with the last will and testament. All right, so a will is extremely important, and I recommend that everyone have a valid will in place. All right, that kind of goes without saying, but it not only, not everyone has a will in place, or perhaps circumstances have changed. All right, so not only does the will identify who you want to nominate as an executor, but it's also going to dictate who the beneficiaries of your estate will be, right? And how much of a gift or what percent of your estate that you want your beneficiaries to receive. Now, I just mentioned an executor. So, what is an executor? Who is an executor? An executor is a fiduciary. So it's an individual or multiple individuals. You can have co-executors. And this person's going to be, in very simple terms, responsible for collecting all of your assets, paying off any debts as of your date of death, and then ultimately making distributions according to the terms of your will. And that means that we're making distributions to your beneficiaries. So, how much these individuals who you've listed or organizations are going to receive. Now, one piece of important information that I want you to remember again, and we touched on this kind of before, is that, if you have a child or a loved one with special needs, you do not want to leave any portion of your estate directly to them under your will. So you don't want to name them directly as a beneficiary. Rather you would leave it to the special needs trust, which would be for their benefit. So for instance, if I was creating a special needs trust for my child, I would be, leaving whatever portion I wanted, whatever percent of my estate would go to, for instance, the Oberweis Family Trust Agreement of 2020, rather than leaving it to, let's say, Jason Oberweis. All right. Now, doing it this way, it allows you to leave money, for your loved one, and it gives them that benefit of having those assets used for their benefit, and over the course of their lifetime, frankly, but it doesn't jeopardize their governmental assistance. It doesn't affect that government assistance eligibility that we had mentioned before. All right. What else can you do under your will? Well, if you have minor children, or if you're presently guardian over, a loved one, let's say a child with disabilities or a young adult with disabilities, who you are the guardian over, you can identify in your will, who you want successor guardians to be. Now, another very common question I'm asked is, how often or when should I update my will? There really isn't a bright line rule for it. Okay. It depends upon what your circumstances are. So let's say, for example, I want you to think about, what is your relationship like, with the various people who you've named in your will? Have there been any deaths since you've last created one? Have there been any additions? Have there been any births? Are there any new family members that you want to provide for? Do you speak with the people, that you've named as executors, or guardian or so on? As a general rule, it's smart to take a look at your will, say maybe every 5 to 10 years to make sure that it's up to date. Really that you have the right people listed in there, that you want to have in there. All right. So there is no bright line rule. The answer is when your circumstances change. But it's also smart every 5 to 10 years to, pull out your will and make sure, it says what you want it to say and it does what you want it to do. All right. So that takes us then into the powers of attorney. Now, when we talk about a financial power of attorney, almost all of the power of attorneys that we draft are durable in nature. And what I mean by durable is in contrast to springing. All right. So a durable power of attorney, it becomes effective immediately upon signing. Now, that's despite any possible future disability or loss of mental capacity. So if you are subsequently disabled or you lose mental capacity, your power of attorney, which you signed originally when you didn't have that disability, when you did have the proper mental capacity, that's going to be in effect. All right. That doesn't necessarily void or cancel out, the document that you have in place. Springing power of attorney, on the other hand, in contrast with the durable nature, it doesn't become effective until you are disabled or until you lose that mental capacity. All right. Generally, at least from what I see, it's not preferred, because you really do need two physicians who are going to confirm that you have this disability or that you have this loss of capacity in order to make this document effective. And there may be instances, where someone needs to act immediately. Let's say, for example, the individual has assets which are invested and it's a volatile market and you need to, sell some investments before the market tanks. You've got to be able to act immediately. Or let's say you have a mortgage that's becoming due, or you have bills that are piling up. So, in my practice, I generally see, for the most part, in all of our practices at Hinkle, Pryor and Fisher, durable power of attorneys are much more common, and preferred. Now, unlike a will, a power of attorney is only effective while you're alive. Okay. So sometimes I'm asked, well, someone passes away, but, I'm the attorney in fact, who's the person who you're naming to make those decisions on your behalf. Once you pass away, the document has no more effect. All right. Once you pass away, your will, your last will and testament, that's going to control. Okay. Now, as I had said before, the person who is so the person who's creating the power of attorney is the principal. All right. You create the document, you sign it, and you designate who you want to serve as the attorney in fact. All right. And this person is going to make financial related decisions. So what does that mean? It means that anything that you can do financially, so can your attorney in fact. Essentially, they step right into your shoes, with regard to financial matters. Now, the purpose of this document isn't to give someone else free access and reign to all of your money. Okay. As a fiduciary, all right, because the attorney in fact is a fiduciary, they are only supposed to act on your behalf if you're unable to do so or with your permission. They're supposed to act in your best interest. Okay. What you would do. Right. So they're not supposed to, you name someone as an attorney in fact, they're not supposed to, take a trip around the world for $50,000. That's not what you would do. The idea is that they're supposed to, help you and assist you, and you nominate someone who you're comfortable with, who you trust, in that regard. With that said, though, the attorney in fact has broad powers. Okay. They can buy property, they can sell property, they can mortgage a home, they can pay off a mortgage, they can pay your bills. Again, anything that you can do financially, so can your attorney in fact. Now, similarly, let's talk about the Advanced Healthcare Directive. Okay, so it's essentially healthcare power of attorney. It's similar to the financial power of attorney, that we just went over, but in this respect, it involves medical and healthcare decisions. So what does this document do? Well, it tells your doctors, it tells hospitals, family, who can have access to your medical information. It tells those same people who gets to make those decisions, the attorney in fact, on your behalf. All right. Now, in order for this document to be used, there has to be two physicians which render you as unable or incapable of making healthcare related decisions for yourself. So this is, your primary physician is going to be the first, physician that's sought, and then it's going to be a second physician, who's chosen by your attorney in fact. So once those two doctors, determine you as, being unable to participate in making those healthcare decisions, then this document is going to become effective. Also, within a healthcare directive, you can provide for other things, such as, providing for any life-sustaining treatment that you want or you don't want. Okay. You can also designate in there whether you want any end-of-life treatments that you do want or that you don't want. So what do I mean by end-of-life treatments? Well, let's say you want, to be cremated, or you want to have Catholic rites or Orthodox Jewish rites, or if there's specific, end-of-life treatment that you want, or burial instructions, if you want to be an organ donor. These are all things that we can include, which illustrates what your wishes are. Now, if you are a guardian, let's say for, a child of yours who has a disability, within the medical directive, we can also include at least what our firm calls as a disabled child provision. All right. So what that does is that states that in the event that, your child were to, be of such a condition that he or she is, again, unable to, advocate for him or herself, you want your wishes to be applied to your child. All right. So whatever your wishes are, you want that to be basically applied to your child. So we can include that as well. Another interesting thing that we sometimes include, depending on who the client is and the circumstances, are we can include what we call a psychiatric advance directive. And what this is going to do is this is going to reflect your wishes as the principal, the person who's creating the document, as far as, what psychiatric treatment or care, which is made during a period of wellness. So, in a period of wellness, and you create this document, it can then be relied upon during a time of crisis. And it also can provide informed consent for treatments which, the principal has predetermined that he or she wants. It can also provide valuable information simply for health and medical information, to doctors and hospitals, in the event of a crisis. So that brings me to the special needs trust, which, we get a lot of inquiries about because, it's a very important tool as part of the estate plan. All right. So generally speaking, assets that are placed in a special needs trust do not count as a resource against the beneficiary for eligibility purposes, for those governmental benefits. And I just want to quickly back up a minute because I've used assets and resources almost interchangeably. Just be mindful of that when you're qualifying for these governmental assistance programs, what they're looking at are resources. All right. Resources are assets, but not all assets are resources. So some assets are excluded, such as those assets which are placed in a special needs trust, and as a result, don't count as a resource against the beneficiary of those services. So there are two types of special needs trusts. Okay. There's a first party special needs trust, and there's a third party special needs trust. And we're going to talk about each of those. First party special needs trust, sometimes you'll hear it referred to as a payback trust or a D4A trust, referring to the statute. A first party trust, special needs trust, can only be funded with the individual beneficiary's own assets. All right. And this is very distinct from the third party, which we'll get to in a minute. So the first party special needs trust can only have the individual's own assets. How does that happen? All right. Generally, it happens, in three circumstances. Let's say that there is an improper inheritance directly made to the individual, right? So if someone creates a will and leaves, a gift, a specific gift or a portion of their estate directly to the individual, as I had given that example before, rather than say the Oberweis Family Trust Agreement of 2020, that would come to the individual, him or herself, rather than going to the trust. Those are then that individual's assets. Another way that we sometimes see this individual come to money is through a lawsuit or a settlement. If there is a lawsuit, or there's an accident, or someone's injured, and it goes to court, and there's a settlement, oftentimes a first party special needs trust will have to be created in order for those assets to be placed to maintain eligibility. And the last part of this is really that, maybe the individual didn't have a disability. And they, it happened over time. One thing I can think of is, sometimes we'll have clients with dementia, right? So, they were working, they have assets, and then as they start to decline, as they get older, now they have these assets that they need to do something with. And at that point in time, a first party special needs trust will also be appropriate. Now, oftentimes you need court approval to establish a first party special needs trust, all right? And we're going to go through the next couple of items, which are directly in contrast to a third-party special needs trust. So with a first-party special needs trust, there's an annual accounting required, okay? So the trustee has to provide an annual accounting, to, let's say, Division of Medical Assistance and Health Services, every year they've got to provide, especially if the individual's receiving services, what the accounting of that first-party special needs trust looks like, excuse me. Another requirement is that the trustee must give, again, Division of Medical Assistance and Health Services, 45 days advance notice of any expenditures in excess of $5,000, okay, throughout the course of the year. Now, that can be either in a lump sum payment, if you're going to spend more than $5,000 for something for the beneficiary, or if it's going to be, let's say, monthly or quarterly, and in the aggregate, it's going to add up, to exceed that $5,000 mark. You've got to give 45 days advance notice. And most importantly, with the first party special needs trust, there is going to be a Medicaid payback provision, which is a major concern. All right. So any funds that remain in a first party special needs trust at the time that an individual passes away, that the beneficiary passes, that is first going to go back to paying any Medicaid lien that exists and potentially any other governmental entities which have provided services. All right. And if you have a loved one who has been receiving Medicaid services for any extended period of time, let alone, a number of years or decade or, multiple decades, that's going to be a very extensive lien. And that you can almost, bet that there's going to be no money left. All right. That money is going to all go back to, pay the state. Now let's contrast that with a third-party special needs trust. A third-party special needs trust, sometimes you'll hear called or referred to as a supplemental benefits trust, where the first-party trust can be funded with only the individual assets. The third-party special needs trust can be funded only with assets belonging to anyone other than that individual. So anyone can fund a third-party special needs trust except for the individual's own assets. Unlike the first-party special needs trust, you don't need court approval to establish it. We prepare the documents, you sign them, the trust is created. All right. Again, unlike the first-party special needs trust, there's no annual accounting that's required. Okay. Unlike the first-party special needs trust, there's also no 45 days advance notice for expenditures, over $5,000. And most importantly, there's no Medicaid payback provision. Okay, so the person who creates the trust, or the people who create the trust, we call them the settlor or the settlers. All right, they get to determine within the trust document itself who the contingent beneficiaries will be. Okay, so in the third-party special needs trust scenario, where the beneficiary were to pass away and there are funds that remain in the trust, any funds that remain, you get to dictate who they go to. All right, so they're not going to go to paying any Medicaid liens off. They're going to go to maybe other family members or other children, all right, or children of the beneficiary who's passed. Now, again, the assets that are placed within the special needs trust, first party or third party, are not going to be counted as a resource against an individual's eligibility for, SSI or Medicaid, okay? But in order to not have those assets count, there are certain restrictions on the use of those funds. So really, the restrictions are that, the funds within the trust must be used for the sole benefit of the beneficiary. All right. You can't have other people enjoying you can't distribute money, so the whole family can enjoy it in addition to the individual. They would want those other family members to, pay their, proportionate share. Generally speaking, distributions from a trust, you really want to avoid them being used for food, shelter, or clothing. Generally speaking, and again, we can get into that all night long. But again, oftentimes the individuals receiving Social Security benefits, SSDIs, Social Security disability insurance benefits, or supplemental security income. That's what's supposed to provide for the individual's basic necessities, what they deem as the food, shelter, clothing. All right. So the trust really isn't supposed to provide for that without having a negative effect in one way or another on that individual's specific governmental assistance. So that leads me to the next question of, well, with all those restrictions in place, what can you use a special needs trust for? All right. Well, anything that the governmental services that the beneficiary is receiving that those services do not provide for, it can be used on. So for example, it can be used for extra therapies or trips, or recreation, supports, transportation, electronics, furniture, stuff along those lines. All right. The general rule is that special needs trust funds must be used to supplement, not supplant or replace governmental benefits. All right. So as a trustee, if you stick to that, you should be okay in managing those funds. So how do you fund a third-party special needs trust? All right, because we're talking about the third-party special needs trust, and perhaps from an estate planning perspective, more of a proactive than a reactive position. Whereas the first-party special needs trust, you're reacting, to the individual coming into money and having to do something with those funds. So how do we fund a third-party special needs trust? I would tell you, most commonly, at least in our practice, we see it funded under a will. Okay, so under the will, let's just say, we have, two parents, husband, wife, husband dies first. Generally, everything is going to be left to the wife. The surviving spouse is going to inherit everything. Now, when the surviving spouse passes, generally that's when a special needs trust will be funded, with either a specific gift or with a percentage of the estate. All right, and there is a reason, why more often than not, and again, everyone's circumstances are different. Sometimes the trust is funded while they're living. But once the funds go in, they don't really come out. And again, once those funds go in, if you're going to contribute into the trust as a parent, you have more flexibility in spending those funds how you wish, without putting them into the trust. There are also maybe income tax returns that are necessary, depending on how the assets within the trust, if they're invested in income producing assets. So there are other concerns. Okay, so more often than not, we typically will have a special needs trust prepared, and we'll have that referenced in the will. The sole parent passes away or the surviving spouse passes away, then the trust becomes funded. Another way to fund the trust is through life insurance, right? So, we don't know, none of us really know when we're going to pass, all right? And we don't know what our assets are going to consist of. So you can leave anything in your will that you want, but if you don't have it at your time of death, you're not going to be able to fund the trust with what you maybe had anticipated or hoped for. So often we'll see life insurance purchased on, one of the parents or both of the parents, where the surviving spouse will be the primary beneficiary, and we'll have the special needs trust as a secondary beneficiary. And in that respect, you can guarantee that there's going to be some fixed amount that's going to fund the trust. Another way to do it is 401k, retirement accounts, IRAs, again, with the beneficiary designated specifically as the trust. It's another way to fund the trust. And then really gifts, it can be gifts from family or friends, parents, distant relatives, or inheritances from others. Again, if you have a grandparent who wants to leave something for their grandchild, you really just want to make sure that they don't leave it to them directly, as counterintuitive as it is, because it's going to have potentially harmful effects on that individual's eligibility. You really want to have them leave it directly to the trust. Now, sometimes, especially with third-party special needs trust, we'll have clients who receive a letter, from Ssdi or from Medicaid, or the Division of Medical Assistance and Health Services, saying, that they need to share a copy of the trust. Just keep in mind that if the trust is unfunded, you really are not under any obligation to share that, with the state, or, Social Security. Once it's funded, though, you are. All right, so just keep that in mind. All right, so those are really the 4 documents that we talk about when we talk about an estate plan. Okay, so now I just wanted to quickly touch on that ABLE account, as I mentioned at the beginning, because again, ABLE accounts are important. They're becoming more popular, so it's worth talking about. All right, so again, ABLE stands for Achieving a Better Life Experience. And the person who gets to make decisions, like a trustee for a trust or a representative payee for Social Security benefits, we call this person an authorized representative. All right. Now, in order to establish an ABLE account, you have to demonstrate that the individual has a significant disability which manifested itself before age 26. Okay. Now, if the individual is receiving SSI or Ssdi and they meet that age criteria, the individual is going to qualify. All right. Similar to a special needs trust, funds in an ABLE account do not affect Medicaid eligibility. All right. You can also have up to $100,000 in an ABLE account without it having any effect on SSI. You can also contribute a maximum of $15,000 per year into the ABLE account. So with the trust, there's no restrictions. Anyone can, fund the trust with however much money they want. The ABLE account can only be funded with a maximum of $15,000 per year, regardless of, who makes that deposit or whom, multiple people are, funding that. All right, and that typically runs in line with the federal gift tax exclusion. So if that number goes up, the maximum contribution to ABLE account may very well go up as well. Now, I just want to caution you on something. So I had said you can have up to $100,000 in an ABLE account without it affecting SSI. You really don't want to use it, too much as a savings mechanism, because like a first-party special needs trust, any funds that remain in that ABLE account at the individual's death, there is going to be a payback provision, typically for governmental liens. What I'm really talking about is Medicaid. All right. And again, if the individual's been receiving benefits for some time, there's a good chance that any money that's within the ABLE account is going to exhaust the remaining balance. All right. So the ABLE account payback is just like that first party special needs trust. So what can you use the funds in an ABLE account for? Well, I mentioned before that, with the special needs trust, you really don't want to, use funds for food, shelter, clothing. With an ABLE account, they specifically authorize distributions for housing. All right, so that housing, that shelter component, that's acceptable through an ABLE account, which, depending on the circumstances, certainly has its perks. You can also have distributions made for education or for, again, transportation, employment training or support, assistive technology, financial management or administrative services, legal fees, expenses for ABLE account, things along those lines. Even funeral and burial expenses, basic living expenses, again, above and beyond the food, shelter, clothing, or food and clothing, excuse me. So again, an ABLE account can be a useful estate planning tool, but it's only, not to use a cliche, but it's really only one tool in the toolbox, and it's best used when it's part of a comprehensive estate plan. All right. All right, so now that wraps up the estate planning part of this, and I just want to get into the estate administration aspect. So we talked about planning for one's estate, when they pass. Well, what happens when they do pass? Now we're talking about the estate administration, okay? So if there is an original will, the named executor or executors are going to be responsible for, reviewing the contents of the will and probating the will. That's done with the county surrogate. Now there's a 10-day waiting period from the individual's date of death, the decedent, before the will can be probated. And we're often asked, well, why someone passed away, why can't I go and probate the will immediately? There's really this 10-day cooling off period where if someone is going to object to the probating the will, for a number of circumstances, they're allowed to file a caveat, to contest the will. So there's got to be a period of time before someone passes and you rush to the courthouse to probate the will. So what do you need for probate? You need a number of things. You need you need an original death certificate with a raised seal. You need the original will, all right, to probate it. An original codicil, if there are any. What's a codicil? Codicil is an amendment to a will, okay? You also need the names and addresses of all immediate next of kin, names and addresses of all beneficiaries that are named in the will. If it's not a self-proving will, you need the addresses of those witnesses. You also have to provide the county surrogate with an approximate value of the decedent's estate. And then the executor or co-executors, when they qualify, need to provide copies of their driver's license and then a check for the probate costs. So what you'll get is letters testamentary, and you'll also get short certificates, which are basically, additional copies. You only get one letters testamentary. You can have as many short certificates as you want. You just pay for, however many you want. So again, once you complete the probate, that's when the letters testamentary are issued. And those documents, the letters testamentary and the short certificates, which essentially reflect the letters testamentary, that gives you the legal authority as the executor to act on behalf of the estate. Now, if there is no original will, if you can't find the original, or if there is no will at all, someone still needs to be appointed. All right, so someone's going to file with the county surrogate for letters of administration. And this person will become an administrator of the estate. Oftentimes, if there is no will, you're going to have that individual is going to have to post a bond really to cover the gross value of the estate assets. Now, moving forward, once you qualify, whether it be as an executor or an administrator, you've got to complete this notice of probate, and that's going to be sent to all beneficiaries within 60 days of probating the will. You then must file a proof of mailing within 10 days after the notice of probate is sent. And really, the court just wants to make sure that you, as the fiduciary, the executor, the administrator, you're doing what's required. You're giving everyone notice to make sure everyone has equal access to what's happening. Now, the executor is responsible for figuring out what assets of the decedent exist and any debts which may be due as of the decedent's date of death. All right, and some ways that this can be done can be determined really are by mail that the decedent receives from family, documents that may be located in his or her house or residence, perhaps professionals such as an accountant, and so on. So that's some of the ways to gather the information. Now, again, after probate, after the notice of probate sent out, after the proof of mailing is sent out, the executor should apply for an EIN. And an EIN is an employer identification number. And you do that through the IRS. And the easiest way to do that is to simply go onto the IRS's website. You can do it electronically. Unless there's a glitch, they typically, generate an EIN, send it back to you immediately. All right. Once the EIN is obtained, you can then open up an estate account. And you want to, put all of the decedent's funds that are due or anything that you need to liquidate. That's then going to go into the estate account. You want to keep that separate, from the executor or the administrator's own personal finances. So there's two things that I want to talk about now, and those are probate assets versus non-probate assets. All right. So non-probate assets are assets, all assets that are held jointly. So let's say you have a checkings or savings account that you hold it jointly with someone, or let's say you have any account that has a beneficiary designated on it, let's say a 401k or an IRA, or any payable on death or transferable on death accounts. Those are all non-probate assets. And what I mean by non-probate assets are that those assets do not pass under the will. So we just talked about the will, right? These pass outside of the will. They pass by operation of law. All right, by that joint designation or by that beneficiary designation within those accounts. Probate assets are all other assets which pass under the will. All right, so it could be checking, savings account, individual bank accounts. It could be real estate, which is held, by the individual, him or herself. It could be a vehicle which is titled in the individual's name. Stocks, again, individual name. So those are, really the big differences, so just want you to be aware of that. Not all assets pass under the will. If you have a 401k, then you have, a beneficiary you've named on that. That's not going to pass under the terms of your will. All right. What do you do after this? Okay. So after you open up the estate account, you have to see there may be an inheritance tax return due. Okay. An inheritance tax return, inheritance tax is assessed based upon the relationship of the beneficiary to the decedent. In New Jersey, an inheritance tax return is due within 8 months of the decedent's date of death. If the beneficiaries are all Class A beneficiaries, by Class A, I mean spouse or parents, children, grandchildren, anything lineally, lineal descendants, you can use a simplified L8 or an L9 form can be used. But again, there are potential other issues with that. You have to make sure you check off all the boxes in order to use the simple form, the L8 and the L9. It's also important to obtain transfer inheritance tax waivers, if there's real property, property that you own, like a home or specific accounts, which need to be transferred, okay? Because financial institutions in New Jersey can release up to 50% in their discretion of accounts, of the balance of accounts without receiving the tax waiver. The tax waiver is going to demonstrate to the financial institution, and it's issued by, the county, that all inheritance and estate taxes are paid. All right, so it gives them the clear to release the funds and that, everything has been paid that should be. I mentioned Class A before, beneficiaries. There are no Class B beneficiaries. Class C beneficiaries really are, the siblings of the decedent. So we're branching out, and there are tax implications on this end. All right, so the first $25,000 is exempt. Then it ranges on a sliding scale from 11% up to 16%. I believe 11% is right around $1,075,000, and anything over anything over 1.7 million is subject to the 16%. okay? Then we have Class D beneficiaries, which are basically all other beneficiaries that aren't A, C, or E, which we'll get to in a minute. Those are Class D beneficiaries, and they also have tax implications. First $700,000, subject to tax of 15%. Anything over $700,000, tax is 16%. And then lastly, we have the Class E beneficiaries, which really are charitable organizations or departments of the state. No tax is going to be due. So we have two taxes. We have the transfer inheritance tax and we have the estate tax. All right. So the estate tax is not based upon the relationship to who's inheriting. It's based upon the gross value of the estate, the total value. All right. New Jersey used to have the lowest threshold for estate tax of $675,000. However, New Jersey has since phased that out. So there is no more estate tax as of January 1st, 2018. Keep in mind, it is certainly possible that this estate tax can be brought back at any point in the future, but for now, there is no New Jersey estate tax. And the last tax that, not many, but, certainly some people may need to be mindful of is there is a federal estate tax. And you would need to file Form 706. And that's really required when the gross value of the estate exceeds in 2020, $11,580,000. So for the most part, most people aren't worried about the Form 706, but in certain circumstances, you have to be mindful of that. Now, once all the valid debts have been paid, then the executor is going to make distributions according to the terms of the will, all right, or according to the terms of the intestacy law, if there's an administrator and there is no will. All right, so that, that's the last step. Now, there's two ways to close out the estate, and you actually want to do this right before you make that distribution, but they're often done simultaneously. So informally, estates are closed out informally most of the time in New Jersey, and that's done through what we call filing release and refunding bonds. All right, so anytime that a distribution is made to a beneficiary, the executor really needs to have that beneficiary have a release and refunding bond that's signed. All right, so once all the distributions have been made, the executor then files all the release and refunding bonds with the surrogates court that they've received from the beneficiaries. The second way to close out the estate is done through a formal proceeding, which is through an accounting action, which can be filed with the surrogates court for approval. It's much less common than the informal route through filing a release and refunding bonds. And it's also costly and timely because you have to pay the surrogates court to make sure that they do their job and evaluate that. So that pretty much sums up my presentation. I just want to quickly point out before we turn to questions is that our office, Hinkle Pryor Fisher, just completed our fall virtual empowerment conference earlier this month in early October. And I just would encourage you, if you're looking for more resources, to check out our website, our Facebook page, and our YouTube channel. We are posting all of the 24 recorded presentations, as well as the keynote speaker, Helen Hones, who is a retired New Jersey Supreme Court Justice. So if you have some time, check that out, and hopefully you'll find some good information on that. So with that, let's take a look at the Q&A box.
Thank you so much, Jared, for that amazing presentation. That was a lot of information, and we have a lot of questions. So thank you so much. I will start with a couple of these questions. Let me just take a look here. Okay. So the first question we have is, if we have a full estate plan from another law firm, will it cost us the same as if we came to you with no documents?
It's a good question. It's a common question we're asked, especially about costs. The answer is it really depends upon what you're looking to do. Okay. You can have powers of attorney, which may be completely fine. But if you need to create a special needs trust and, almost always we're going to have that put in the will, and you have a will already, you're going to have to update your will to reference that. So we charge a flat fee, at least for our estate planning. We try to make it as simple as possible. People don't like to pay hourly rates, so we have a flat fee, and it really just depends upon what you're looking to accomplish. And again, without having more information, I know that there's quite a number of people signed on here. I would encourage you to reach out. We'd be happy to chat about that.
Thank you so much. Another question, is the special needs trust revocable or irrevocable?
It's a good question. So oftentimes, the first part is going to be irrevocable. Okay. Because again, oftentimes almost always you need court approval to establish that. The third party special needs trust is revocable up until the point where it's funded. Okay, so once it's funded, it then becomes irrevocable. So if you create the special needs trust, the third party special needs trust, you're not funding it until the second spouse passes, and you realize that your successor trustee after the parents you no longer talk to, or God forbid something's happened to them, and you want to make sure that there are other people named in the document, you absolutely can modify the document. But if you have a special needs trust already, different attorneys' offices draft them differently. So you really need to take a look at the language to see what is in that specific trust.
Absolutely. Thank you so much. And just to let everyone know, we will try to get to as many questions as we can up to 8 p.m. So here's another one. If we move to another state like Florida from New Jersey, would special needs trusts in New Jersey be valid in Florida?
It should be, depending on who drafted it. I can tell you, our firm has language in all of our documents that, solely upon you moving to another state, the documents are all still going to be valid. All right. But if you're moving to another state permanently and you intend to live there, indefinitely, and there has been, a lapse of time, you may want to consult, an attorney within that state, to find out about their specific local rules.
Mm-hmm. Thank you. If you establish a power of attorney, can you change it later to designate someone new?
Absolutely. And just to go further, you can also do that with a will. So these documents are not necessarily set in stone, unless you have a third party special needs trust, which has been funded. And again, you may be able to tweak it here and there depending on what the revisions are. But again, that's our language in the document. Everyone drafts different documents. So if you have powers of attorney, we don't. Let me just back up. So, before I had mentioned codicils, so there's two ways to, change the will. You can either have a codicil, which is basically an amendment, which goes right on top or right behind, the document. But you can see what the previous iterations of that document were. So oftentimes, we have clients who would prefer just a brand new document because, especially if you're changing distribution percentages, and you don't want the person who perhaps is receiving a lower distribution, or a lesser distribution, you may not want that to be visible to everyone. So oftentimes we create a brand new document. The powers of attorney, we really don't do amendments to. All right. So they're pretty simple documents. If you need to change it, we create a new document, which will revoke the previous documents that you've had in place.
Thank you. If my adult child has not yet applied for SSI, do they need to be disabled in order to set up a special needs trust?
It's a good question. They do not have to, they don't go hand in hand. So, obtaining SSI eligibility is not necessarily a prerequisite, to a trust. We'll have clients who come in who have, they'll have a younger child, let's say 10 years old, who has special needs, and they want to plan for, his or her benefit if something were to happen to them. They're not going to be SSI eligible because keep in mind, you really aren't going to apply for SSI until, the child turns 18, because once they're under 18, they're going to deem the parents' assets as their assets. And, 99.9% of the time, the parents are going to collectively have more than $2,000 in assets, which are not, you're going to disqualify, their child from SSI. So that's not necessarily a prerequisite. I would not hold off until you get your, child SSI eligible.
Thank you. Is College Fund 529 considered an asset?
Great question. It is for SSI. Okay. So, when we're working with clients, you can change the beneficiary to another child. You can also roll over a 529 plan into an ABLE account, which we've had many clients do. So if you do have a 529 plan, be mindful of that, at least as far as applying for SSI and or Medicaid. So that very well may count against them.
Do you need to notify SSI or Medicaid when a third-party trust is created?
Also a good question. You'll find yourself in less hot water, if you will, if you notify them, but again, they're not entitled to a copy of the trust until it's funded. And if there are no funds in it, they really don't need to know that there's a beneficiary of nothing. once that's funded, they are entitled, to be put on notice on that.
Can a trust specify that beneficiaries maintain full-time employment in order to get a monthly stipend from their inherited funds?
So I think I understand where this question is going. If we're talking about a third party with any special needs trust, the individual cannot get cash outright. Okay, so not only can the funds not be spent on food, clothing, and shelter, but you can't give cash directly to the individual. Any cash distributions are going to be deemed income to the beneficiary, and that is going to reduce that's going to count dollar for dollar what their income is. All right, so you don't want to have any stipends per month. You're going to run into issues with that. As far as maintaining full-time employment, that can get very tricky. Excuse me. That's the beauty of doing these from home. You really. No. All right, so that really isn't a condition that's going to be found in the special needs trust.
It's okay. No worries. Okay. So we have put money in a trust now, and we have to file taxes with the IRS or that trust. Is that what you were saying?
So what I was trying to say is that, oftentimes trusts are not funded, right? Third-party special needs trusts are not funded during the individual's or during the parent's lifetime because there may be tax consequences. And that really is a question you want to ask your accountant or your CPA. But if their funds are in the trust and it's generating income, you very well may have tax considerations, but that really is best for a tax professional.
Thanks. Children who get SSI at 18, but parents are working. Once parents retire, can a child apply for Ssdi?
Absolutely. Okay, and we often see this, and this is not the focus of tonight's presentation, but real quickly, and let me just make sure we have some time. So oftentimes what will happen is the individual is getting SSI, the parent either retires, the parent becomes disabled, or the parent passes away. The child is then going to get a bump up, and they should start collecting Ssdi. And if that doesn't happen, you want to reach out to the Social Security Administration and put them on notice. Ssdi is almost always going to be higher than the SSI amount, or it'll be less, and you'll receive SSI and Ssdi. Keep in mind that in New Jersey, once you qualify for SSI, you automatically get Medicaid. And Medicaid often sets you up for, future services, let's say through the Division of Developmental Disabilities. So when you get that Ssdi amount, let's say it's higher, in New Jersey, I believe the federal maximum benefit is $783 for SSI. That's generally speaking. So if your Ssdi benefit is going to exceed that, you're going to lose your SSI. And in turn, you're then going to lose your Medicaid, which poses a problem, especially if you're receiving services which requires Medicaid eligibility. And in that situation where that happens, you can apply through the County Board of Social Services to have the Medicaid reinstituted under a DAC status, DAC being a disabled adult child. So hope that was a long-winded question to your answer, but just understand that yes, you can have SSI and Ssdi, but oftentimes Ssdi will phase out the SSI, and I believe that the child will receive 50% of their parents' benefit.
Thank you. And in regards to a trust, so someone is mentioning that their son inherited money and it's not available to them until 25. Once they turn 25, should they set up a new trust right away?
So if your son is receiving benefits, let's say he's on Medicaid or he's receiving SSI, once he is able to come into those funds, you really do want to create a first party special needs trust. Now, it depends on how much funds are in that trust, okay? If the funds are under $15,000, I would tell you to set up an ABLE account, all right? Because you can transfer those funds directly into the ABLE account and avoid having to go through the court process of establishing a first party special needs trust. If it's $20,000, you may be able to put the $15,000 to the ABLE account and spend $5,000 on your son, for his benefit. If it's more than that, there may be some other options, but you are going to have to do something with those funds to avoid jeopardizing the benefits he's receiving.
Thank you. We have about 5 minutes, so maybe about 2 or 3 more questions. What would happen if I do not have anyone who can be the executor to make decisions for my 2 children who are over 18? Who are over 18 and have a mental illness?
That becomes an interesting question. It's easier said than done, but you really want to see if there's anyone, who can do it. Ultimately, you may end up having an administrator, where there isn't an executor named under the will who ultimately ends up qualifying. It also depends on how many assets are there. I've seen estates where the assets were really nominal, where they've been invested in all non-probate assets. So, there really wasn't a need to probate the will, if there was nothing to be distributed according to the terms of the will. So for that, I would really, I don't have enough information. It's an interesting question. I would encourage you to try to find someone to put down as the executor in your will. And I certainly encourage everyone to try and put a backup in their will. But those are circumstances that, you really need to consider.
Thank you. Can an asset be transferred to a special needs trust that was left to someone prior to setting up the trust if they are receiving Medicaid assistance?
Could you just repeat that, please?
Yeah, no problem. Can an asset be transferred to a special needs trust that was left to someone prior to setting up the trust if they're receiving Medicaid assistance?
So if I understand this question, in funding a third-party special needs trust can be done with anyone's assets other than the beneficiary. Okay, if they're receiving Medicaid, you can certainly transfer. You're going to have to transfer the funds into the trust. But again, if you're receiving Medicaid and it's your funds, I think you're talking about a first-party special needs trust. And oftentimes you're going to have to petition the court and tell them those facts. You've come into money, you're receiving Medicaid. If they don't approve this trust, it's going to have a harmful effect on the individual, on the benefits that he or she is receiving.
That makes sense. If my child, hold on one second, let me try to, here's an ABLE account. How do you recommend using a first party special needs trust and ABLE account together to support our disabled child?
So another good question. I also need some more facts to kind of help me, what you're trying to accomplish, but one thing, specifically for housing, I can tell you, and, the Division of Medical Assistance and Health Services, really Medicaid, what they're looking favorably upon is, transferring $15,000, from the special needs trust, giving 45 days advance notice, because again, it's, that expenditure is over $5,000 to the ABLE account to be used for housing. All right, so that is one way that you could use those, collectively, but it's an interesting question. And again, without more facts, I would encourage you to, reach out and, we can have that conversation.
Thank you. And I'll go with one more question. Can you buy a home for a beneficiary and not count it as resources?
Good question. You can. An individual is entitled to have their own home. But what we tell clients is that you really want the trust to purchase the home in the trust name. And then what we would do is you would have the individual pay a reasonable portion of rent to the trust because the trust is the owner. It's like a landlord. Just to quickly point out where we encourage the trust to own the property directly, because again, if the trust owns the home, it's not the individual's asset, right? And then that individual will be paying rent. Unlike that, I would discourage anyone, as a trustee from buying a vehicle and putting it in the trust's name, because, the flip side of that is what you really don't want to do is you don't want to expose the trust to potential liability, or a lawsuit if the vehicle were to get into some accident. So trust could buy the home. I would encourage, the trust to, the trust could pay for a vehicle, but you want to have it titled in someone else's name, and the trust would have a lien on that vehicle.
Thank you so much, Jared. And I know it is 8 o'clock, but I just have one more that I wanted to ask you, which is, how is special needs defined?
It's a good question. It's really defined by the Social Security Administration. All right, as far as what a disability is, there is statutory for the U.S. code which, provides for, the special needs trust, the first party special needs trust. They also, I believe, define it in there. But again, if your loved one is receiving SSI or SSDI or Medicaid, there's a good chance that they're going to qualify.
Absolutely. All right. Well, it is 8:01, so I don't want to keep you, Jared, or anyone else this evening. But I just want to take the opportunity to thank you so much for sharing all of this valuable information. And I do want to take a couple minutes to share my screen to show our NAMI New Jersey webinar services before we conclude tonight. So just bear with me 1 second as I share my screen so everyone can see where they can find this webinar. Okay. All right, so this is our main screen, so www.naminj.org. And if you go under events, you will see webinar series as well as our calendar. So I'm going to click webinar series. And as you will see here, this is all of our webinars that we've had since March. Right here is the one that was tonight with Jared. So this is where our recording will be to the YouTube video. In addition, we have some other YouTube videos that you're more than welcome to view. Something else I do want to highlight our online support group. So if you go to support and then you click online support groups, we are offering a family support group on a weekly basis, twice a week, and NAMI Connection Recovery Support Group twice a week. And you can register here. Also on the second Thursday of the month, we do offer a spouse partner support group. We do still have COVID-19 support and resources under our programs. And this is where you will find all our key online services that are available through NAMI New Jersey. And again, thank you everyone for joining us this evening. And thank you again, Jared, for the great information you've provided everyone. I'm sure there's going to be more questions within our survey, and we will definitely try to gather those topics and see what other webinars we can offer to help everyone. So thank you and have a fantastic night.
Thank you, everyone.